Welcome to the Deep Dive. Our mission today is sharp and focused, giving you the strategic knowledge you need to navigate the single most important hurdle in patent law novelty.
That's right.
If an invention isn't truly new, if it has already been disclosed in the public domain, it cannot be patented, period.
That really is the core rule. And today, we're drilling straight into the statutory language of 35 U.S.C. Section 102.
Okay.
This is the definition of novelty under the current America Invents Act, or AIA, system. You can think of this section as the gatekeeper.
The gatekeeper, I like that.
Yeah, it defines novelty and critically outlines what the law calls prior art.
Right, prior art, that's the key term, isn't it?
It is. It's that massive body of existing public knowledge that waits potentially to invalidate a patent application.
So the outcome for you, the inventor listening right now, rests entirely on timing and, well, discretion. Our deep dive today is designed to simplify this pretty complex statute and show you exactly where the pitfalls lie.
And the fundamental rule is simple enough on the surface. If your invention was already known, used, described, sold, or patented before you officially filed your patent application, you lose novelty.
And we're going to simplify this statute, or try to show just how broad that net really is.
Exactly, because under the current AIA system, which shifted to a first-inventor-to-file model, well, the rules are stricter in some ways, but maybe clearer.
Clearer, okay.
How so? Any public disclosure anywhere in the world, and we'll get into what public means, from something like a secret commercial transaction.
Even secret? Why?
Yes, even secret sales, as we'll see. Or even a single academic paper tucked away somewhere that can instantly disqualify your invention.
Okay, so the stakes are high. Let's unpack this map of novelty, starting with the foundation of the law itself.
Right. So we begin with the primary rule for novelty. 35 U.S.C. Section 102. This sets the standard.
This is the main event.
Pretty much. It says a person is entitled to a patent unless, and here's the condition, unless the claimed invention was already available as prior art before the effective filing date of the application.
Okay, effective filing date. That sounds like a technical term, but a crucial one.
It's absolutely critical. Essentially, it's the date the Patent Office officially received your application. Or sometimes it can be an earlier date you can claim through related filings, like a provisional application.
Got it. So everything that happened publicly before that specific date is potentially fair game as prior art against you.
Precisely. And this leads us right into the fundamental policy change that really reshaped American patent law.
You mentioned it earlier. The shift from first to invent to first-inventor-to-file.
Exactly. Before the America Invents Act, the AIA, if two people invented the same thing, the first one to actually invent it.
Not file it, but invent it.
Right. The first to conceive and reduce it to practice. Even if they filed their patent application later, they could potentially win the rights.
That sounds incredibly chaotic. I mean, how would you even prove who invented first?
Well, it often led to endless, very expensive litigation, interference proceedings, they were called. Inventors had to collect years of complex evidence, lab notebooks, witness testimony, prototypes, just to prove they had that initial spark of genius first.
What a nightmare.
It really could be. So the AIA, enacted back in 2011, aimed to streamline the process significantly. It aligned the U.S. with, frankly, the rest of the world.
By moving to first-inventor-to-file.
Correct. Now it's essentially a race to the patent office. Whoever gets their application properly filed first, assuming it meets all the other requirements, secures the priority date.
It sounds simpler, maybe fairer in a way, but also more pressure.
It is simpler administratively, yes, but it places this immense burden on the inventor to either maintain absolute secrecy until filing or file immediately upon invention. The window for delay is much smaller.
And you mentioned the scope of prior art also changed, broadened.
Dramatically. Before the AIA, there were these specific geographical boundaries. Certain types of prior art, like public use or sales, only counted if they happened in this country, meaning the U.S.
Ah, okay. So foreign activity might not have counted before.
For certain categories, exactly. That geographical limit, it's gone. Vanished.
Wow, that's a huge change.
It really is. The new law under the AIA is explicitly global for almost all types of prior art defined in 102A1.
So a published document, a patent from another country, a public use, a sale.
If it meets the criteria we're about to discuss, it counts as potentially invalidating prior art, regardless of whether it happened in Boston or Berlin or Bangalore. Geography doesn't shield you anymore.
Okay, let's dive into the section I think most inventors worry about the most. 102A1.
This is the big one, yes.
This defines all the ways an invention can be barred from patentability because it was somehow publicly available before the inventor filed their application. This feels like where most people might accidentally lose their rights.
That's a fair assessment. This subsection, 102A1, covers 4 specific types of activities or disclosures: patents, printed publications, public use, and being on sale.
And there's that other bit too.
Right, and the crucial catch-all phrase at the end. These are collectively known as the statutory bars, because if your invention falls under one of these before your filing date, the statute bars you from getting a patent.
We definitely need to pay special attention to the language here. You mentioned that critical final clause.
Otherwise available to the public.
Right. What's the significance of adding that?
It ensures the list isn't exclusive. It's a safety net for the law. If the invention was accessible to the relevant public in any form that doesn't fit neatly into the first 3 categories, maybe a physical demonstration at a trade show, certain oral presentations, maybe even a display.
As long as it wasn't confidential.
Exactly. If it was accessible, it's still considered prior art under this catch-all. This really underscores that concept of global availability that the AIA emphasizes. Hashtag 2.1, patented or printed publication.
Okay, start with the most common one I mentioned, written disclosure.
Patents and printed publications.
The rule seems straightforward. If the invention was described in any patent or printed publication anywhere in the world, Before your effective filing date, you're barred.
That's the rule.
But what exactly counts as a printed publication? I think most people might picture, a textbook or a major scientific journal or a magazine article.
And that definition is far, far too narrow in patent law. You have to think much broader.
Okay.
Our sources and decades of case law confirm that printed publication is really an expansive term of art. It covers things like online disclosures, websites, blogs, forum posts, if they're accessible.
Even forum posts?
Potentially, yes. Also, technical journals, obviously, conference papers, academic theses and dissertations, even sometimes poorly indexed internal reports if they somehow became accessible outside the company.
So the key isn't mass distribution?
Not at all. The absolute key is accessibility to the relevant public. Not how many copies were printed, not how widely it was circulated, not even if it was indexed perfectly in a database. Was it placed somewhere that the public, or specifically those skilled in that particular technical field, could reasonably find it if they were looking?
And that accessibility threshold can be surprisingly low, can't it? This brings us to that landmark case in Ray Hall.
Ah, yes, Hall. It's the perfect, almost extreme example to illustrate just how broad this rule is.
What was the publication in that case? It wasn't a journal article, was it?
No, not at all. The prior art in Hall was a single doctoral thesis, a PhD dissertation.
Okay, happens all the time.
Right, but this was just one physical copy. It was submitted, cataloged, and placed on the shelves in the library of the University of Göttingen in Germany. It wasn't checked out, it wasn't copied, it just sat there.
Just one copy in one library in Germany.
Exactly. And the court, the Federal Circuit, had to decide, was this single non-circulating copy available to the public sufficiently to count as a printed publication?
What did they say? This seems like a tough call.
They ruled, yes, it was. Their reasoning was that because the thesis was indexed by author and title, and it was placed in a library that was generally open to the public, even if that public was primarily academics, it was deemed sufficiently accessible.
Wow.
It's a crucial insight for inventors. You don't need a million copies. You don't need online distribution. You just need to demonstrate that the information was put somewhere, somehow, that made it findable by those who might be interested. Accessibility, not actual access, is the trigger.
So the mere potential for discovery is enough.
Mm-hmm.
And this principle isn't just some dusty old rule, right?
Mm-hmm.
It applies directly today, even in the digital age, like in GoPro v. Contour.
Absolutely. GoPro v. Contour is a much more modern application of the same principle. The prior art, there wasn't a thesis, it was a product catalog.
A catalog, like something you pick up at a store.
Sort of, but this was distributed at a trade show open to industry professionals, the relevant public in that field.
Mm-hmm.
It wasn't peer-reviewed, wasn't in a formal journal. But the catalog contained detailed descriptions and illustrations of the invention. And crucially, it was handed out without any confidentiality restrictions.
And the court said?
The Federal Circuit ruled that, yes, this catalog qualified as a printed publication under the law because it was sufficiently accessible to the relevant public at that trade show.
Now wait, there's a technical nuance here we need to add, isn't there? Just describing something isn't always enough. The publication needs to be enabling, right?
Yes, that's a very important qualifier. You're absolutely right. For a publication to anticipate a claim to bar it under 102, it generally must contain an enabling disclosure.
What does enabling mean in this context?
It means the publication has to contain enough information, enough detail to allow a person of ordinary skill in that specific technical field, a fauceta as lawyers call them, to make and use the invention without needing undue experimentation.
So it can't just mention the idea vaguely.
Exactly. It has to actually teach how to do it. If the reference is too high level, too speculative, or missing critical steps, it might not be considered enabling.
And if it's not enabling?
Then it might not technically anticipate the claim under 102. However, and this is important, even a non-enabling reference could still be used later to argue that your invention was obvious under a different section of the patent law, section 103.
Okay, so enablement is key for anticipation, but even non-enabling stuff can cause problems later. Got it. Hashtag tag 2.2, public use.
All right, so we've covered written bars, patents, and publications. Let's move to the physical acts that can invalidate a patent. Public use.
The public use. So actually using the invention out in the world.
Essentially, yes. If the invention was used publicly before the effective filing date, it becomes prior art. Again, this doesn't necessarily require widespread use, but the use must be accessible to the public or, crucially, not conducted under adequate confidentiality restrictions.
This section has one of the most, well, frankly surprising historical examples about what public can mean. The Corset Springs case, Egbert v. Lippmann.
Oh yes, Egbert. It's a classic from 1881, but the principle is still cited today. It's a fantastic illustration of just how strictly the courts interpreted public use, even back then.
So what happened? Corset springs.
Right. Mr. Egbert invented some new, improved metallic springs for corsets. He made a few prototypes.
Okay.
And he gave them to a close friend who later actually became his wife. She then used these corset springs privately in her own clothing for several years before he filed the patent.
It seems pretty private to me. I mean, it's underwear, essentially, used by one person. How on earth did the Supreme Court rule this was public use sufficient to bar the patent? It feels completely counterintuitive.
It does on the surface, but the court focused on a few key things. First, the use was by a third party, his friend. It wasn't the inventor using it himself for testing.
Okay.
Second, and critically, she was under no express obligation of secrecy. There was no NDA, no instruction to keep it confidential. And third, her use wasn't primarily for the inventor's benefit in terms of experimentation or refining the invention. She was just using it. The inventor had effectively relinquished control and confidentiality over those prototypes given to her.
So the logic is, if it's used by someone else without secrecy and not under the inventor's direct control for testing, it's public, even if literally no one else sees it.
That was the court's reasoning in Egbert. If the use is unrestricted and occurs outside the inventor's direct supervision and control for refinement purposes, it qualifies as public use.
So this highlights a really critical distinction for inventors today, right? The difference between that barred public use and permissible experimental use.
Exactly. That's the safe harbor.
How does that work? If I give a prototype to a friend, but I do it differently than Mr. Egbert.
Yes. If you give a prototype to someone, but you specifically instruct them, perhaps in writing, to monitor its performance, report detailed findings back to you, maybe keep records, and crucially, agree to keep it confidential, perhaps sign an NDA.
Then it might be okay.
Then it likely qualifies as experimental use. The courts explicitly allow an inventor to conduct necessary experiments to perfect the invention, even if that involves members of the public using it, provided that use is strictly controlled, monitored, aims at technical refinement, not just market testing, and maintains confidentiality.
So control and purpose are key.
Absolutely. And modern cases like Day v. Sonovian just reinforce this. Any use by a third party today without those strict confidentiality agreements and a clear, documented experimental purpose tied to refining the invention, it's going to be deemed public use. Doesn't matter where it happened or how visible it was. The lack of restriction is the killer. Hashtag 2.3. On sale.
Okay, moving from used to commerce, let's talk about the on-sale bar.
Another major hurdle.
The basic rule sounds simple. If the invention was commercially offered for sale before the effective filing date, it's prior art.
That's the essence of it.
But this rule seems particularly harsh because, unlike publications, the offer doesn't even need to be public knowledge, right? And the product doesn't actually have to be sold or delivered.
Correct on both counts. This is critical. Unlike publication or public use, where accessibility is often key, the on-sale bar is triggered purely by commercial activity aimed at exploiting the invention.
So how do we determine if this bar applies? Is there a test?
Yes, there's a well-established two-part test that comes from the Supreme Court case Pfaff v. Wells Electronics.
Okay, Pfaff, let's break down that test.
It's straightforward conceptually. Both parts must be met before the critical date, which is usually 1 year before the filing day due to the grace period we'll discuss, or the filing date itself if no grace period applies.
Got it. What's the first part?
First, the invention must be ready for patenting.
And second?
Second, the invention must be the subject of a commercial offer for sale. Not just internal discussions, but an actual commercial offer to an external party.
Okay, let's dig into ready for patenting. That sounds a bit vague. What does it mean?
It can be met in two ways. The most obvious is if the invention has been reduced to practice, meaning a physical working embodiment of the invention has actually been built and tested sufficiently to show it works for its intended purpose.
Okay, a working prototype.
Right. But, crucially, you don't need a physical prototype. The invention is also considered ready for patenting if the inventor has prepared drawings, detailed specifications, or other written descriptions that are sufficiently complete to enable a person skilled in the art to actually make and use the invention. This is sometimes called constructive reduction to practice.
So if you have enough detail on paper to file the patent application, it's considered ready for patenting, even if you haven't built it yet.
Exactly. You don't need a finished manufactured product. You just need a finished concept that's documented well enough to be patentable.
Okay, that clarifies the first part.
Oh, yeah.
Now, the second part, the commercial offer for sale. This leads us straight into probably the most controversial post-AIA decision in this area. Helsinn v. Teva.
Yes, Helsinn was huge. It dealt directly with secret sales.
Secret sales. So the offer was made. Maybe a deal was even struck, but it was done under a non-disclosure agreement, an NDA.
Precisely. The core question was whether the AIA changed the old rule. Remember that phrase in 102A1, otherwise available to the public.
Right, the catch-all.
Many people argued, quite logically it seemed, that a secret sale, where the buyer is bound by an NDA, couldn't possibly make the invention available to the public. So they argued secret sales should no longer trigger the on-sale bar under the new AIA language.
That makes sense. If it's secret, it's not public, right? Seems like a direct contradiction in the statute otherwise.
That was exactly the dilemma the Supreme Court tackled in Helsinn. What they concluded was, essentially, that Congress, when drafting the AIA, didn't clearly signal an intention to overturn the very long-standing pre-AIA precedent that any commercial offer for sale, even a secret one, triggered the bar.
So they stuck with the old rule, despite the new available to the public language. Why? What's the policy thinking there?
The key rationale, the court suggested, is that the on-sale bar isn't just about preventing public disclosure. It's also, maybe even primarily, about preventing inventors from commercially exploiting their invention, getting sales revenue, testing the market for a long time before they file for a patent. Doing so would effectively extend their monopoly period beyond the statutory limit granted by the patent.
So it's about preventing double dipping, getting market benefits early and getting the full patent term later.
That's a good way to put it. The Helsinn ruling confirms that the on-sale bar remains incredibly strict. Once you make that commercial offer, even if you keep the technical details completely secret under NDA, the clock starts ticking. You are potentially barred unless you file your patent application within the grace period.
Wow. Okay, so the takeaway is crystal clear. Any commercial offer, secret or not, starts that 1-year clock. Commercial gain and seeking patent exclusivity are essentially mutually exclusive until that application is on file.
That sums it up perfectly. Hashtag 2.4, otherwise available to the public.
All right, let's quickly revisit that catch-all phrase we mentioned, otherwise available to the public.
The safety net.
This is the Patent Office's tool, or the court's tool, to catch disclosures that don't fit neatly into patents, publications, public use, or on sale.
Exactly. It's a residual clause designed to be broad and intentionally flexible to capture unforeseen ways information might become accessible.
What kind of things might fall under this?
Think about maybe detailed physical models displayed at a museum or a trade show without any restrictions, Or perhaps certain types of oral presentations, if they were sufficiently detailed and enabling and, crucially, lacked any expectation of confidentiality.
So it's less about the format, print, sale, use, and more about the simple fact of accessibility. If the information got out there somehow, without strings attached.
That's the core idea. A good example comes from cases involving, say, presentations at medical conferences. Look at Medtronic, Inc. v. Berry. If an inventor stands up and presents highly technical details of a new surgical device, how it's made, how it works to an audience of skilled surgeons or engineers.
And there's no confidentiality agreement covering the attendees.
Right. If that presentation contained enough detail for those skilled attendees to understand and potentially replicate the invention, a court might well rule that the presentation itself, even if no paper was published, rendered the information otherwise available to the public under this catch-all.
So the key again is the lack of restriction. If you make it accessible to any relevant segment of the public, even briefly, even orally, you risk losing novelty.
That's the danger, yes. Okay, so far, everything we've discussed under 102A involves disclosures or activities that were, in some sense, public before you filed.
Right. Publications, uses, sales, public availability.
Now let's pivot to something different, covered under Section 102A2. This deals with what's often called secret prior art.
Secret prior art. That sounds ominous. What is it?
This covers U.S. patents, or more commonly, published U.S. patent applications that were filed by someone else before your effective filing date.
Okay, filed before me. That makes sense as prior art, but why secret?
Because when you file your application, that earlier application might still be confidential, locked away at the patent office. Patent applications typically don't publish until 18 months after they're filed.
Ah, I see. So I could file my application today, thinking my invention is totally new, but unbeknownst to me, someone else filed basically the same thing 6 months ago, and their application just hasn't become public yet.
Exactly.
And that secret, earlier filing still counts as prior art against me. How is that fair? How would I even know?
You wouldn't know at the time of filing. The patent examiner discovers it later during their search. This subsection, 102A2, is absolutely essential for preserving the integrity of the patent system under the first-inventor-to-file rule.
Why is it essential?
Its purpose is straightforward: to prevent two different inventors from independently getting patents on the exact same invention.
Okay, walk me through that. Let's use an example. Inventor A files a patent application on January 1st.
Right. And they keep it secret. Maybe they don't request early publication. It sits unpublished at the PTO.
Then, on March 1st, Inventor B, working completely independently, invents the same thing and files their own application.
Okay.
What happens when Inventor A's application finally publishes, maybe 18 months after that January 1st filing?
When Inventor A's application publishes or issues as a patent, the law effectively says that document becomes prior art against Inventor B, but it gets the benefit of its earlier January 1st filing date.
Ah, so it retroactively invalidates Inventor B's claim, even though B filed before A's application was public.
Correct. Inventor A's filing date acts like a time machine, reaching back to block any subsequent filer claiming the same invention. This section ensures that once an inventor stakes a valid claim at the PTO by filing, any later claim for that same subject matter by someone else is blocked, even if the world didn't know about that first claim for a while.
So it prevents overlapping patents for the same thing.
Precisely. This concept isn't entirely new. Its foundations go way back, recognized in cases like Hazeltine Research v. Brunner. The rule ensures that the public domain, including things already claimed by others at the PTO, even if secretly for a time, is considered when determining true novelty. Ultimately, the public only has to deal with one valid patent for one specific invention.
Okay, if you're an inventor listening to all these ways you can lose your patent rights, I mean, a single thesis in Germany, a secret sale, an unpublished application filed a day before you might feel completely boxed in.
It can certainly feel that way. The prior art landscape is vast.
Thankfully, the AIA didn't just broaden the prior art. It also established some crucial safety nets, some exceptions, right, to protect inventors, maybe from themselves sometimes.
Absolutely. That brings us to Section 102B. These are the exceptions, the inventor's lifeline in many situations.
What's the goal of these exceptions?
They're really designed to facilitate things like research and development, legitimate collaboration, and critically, to allow inventors a limited window to, say, test the waters commercially or academically before having to commit to the expensive and complex patent filing process, tag 4.1, the one-year grace period, Section 102B1. And the most important of these exceptions, especially for individual inventors or small companies, is the one-year grace period.
Okay, the grace period. This sounds vital.
No.
Let's define the rule very clearly, because I suspect this is where a lot of misunderstandings can happen.
It's crucial to be precise here. The rule under 102B1 says this: if a disclosure like a publication, public use, or sale that would normally fall under 102.1 happened 1 year or less before your effective filing date.
Okay, within that 1 year window before filing.
And this is the key part. And that disclosure was made by the inventor themselves, or by someone who got the information from the inventor, like a collaborator who published.
So it has to originate with the inventor.
Yes. If both those conditions are met within 1 year and originates from the inventor, then that specific prior art disclosure does not count against you under 102A1. It's carved out. It's excused.
That is hugely significant. So let me see if I understand. I could, for example, present my brand new invention at a major industry conference today, fully disclosing how it works. And I can do that, secure in the knowledge that I have exactly 365 days from today to get my patent application filed. And my own presentation cannot be used by the examiner to say my invention isn't novel.
Yeah, that's precisely the shield the grace period provides. It gives you, the inventor, time after your own disclosure to gauge market interest, maybe attract funding, finalize the technical details, without immediately forfeiting your U.S. patent rights due to your own necessary public activities.
Okay. Cases like Enrique Kantz, I believe, touched on this historical logic, protecting the inventor after self-disclosure.
Yes, the principle of allowing inventors some breathing room after disclosure has deep roots, and the AIA codified this specific one-year grace period for inventor-originated disclosures.
But T, and this feels like a very big but, there's a vital distinction here that I think often gets missed. This grace period is a shield against your own disclosure, or disclosures derived from you.
Correct.
It is not a complete freeze on the rest of the world's activity, is it?
Absolutely not. This is probably the most critical strategic point about the grace period. It's a personal shield, not a universal moratorium.
Explain that. What if someone else is working on the same thing?
Okay, so you disclose your invention at that conference today. You're protected from that disclosure for 1 year. But let's say 6 months from now, a completely independent third party, someone who never saw your presentation, never heard of you, invents the exact same thing and publishes their own detailed article about it.
Okay.
That third party publication, because it was not derived from you, immediately becomes valid prior art against you under 102A1. Your grace period offers zero protection against that independent intervening disclosure by someone else.
Wow. So if that happens, I lose my novelty unless I've already filed.
Or, unless you can file immediately and prove your invention date somehow predates their publication under very specific, complex exceptions that rarely apply now. Realistically, yes, that independent third-party disclosure during your grace period can kill your patent rights if you haven't filed yet.
So the grace period is a very narrow shield, protecting you only from yourself. It doesn't stop the clock on the rest of the world. You still need to file as soon as reasonably possible, even after your own disclosure.
That is the safest strategy, yes. The grace period is helpful, but relying on it fully is risky because of what others might do independently. Hashtag 4.2, common ownership exception. Section 102B2. Now, the second major exception, under 102B2, deals with that secret prior art we talked about, the earlier filed U.S. patent applications under 102A.
Right, where inventor A files, then inventor B files later, and A's filing bars B even though it's secret at the time.
Exactly. But what if inventor A and inventor B work for the same company? Or maybe they're collaborating under a joint research agreement between two universities.
Okay. If there's no exception, the company's own earlier work could potentially invalidate its later related inventions. That seems problematic for R&D.
It would be extremely problematic. Large research organizations would constantly risk having their own internal progress inadvertently cannibalize their subsequent patent filings. Imagine different teams working on slightly different aspects of the same technology.
So what does this exception do?
The rule under 102B2 says that if the earlier filed patent or application, the potential 102 prior art, and the later claimed invention were, at the time the later invention was made, either commonly owned, for example, by the same company,
Okay.
or were subject to a formal joint research agreement, JRA, then that earlier filing is disqualified as prior art against the later invention. It's simply removed from consideration under 102A2.
That seems like a very practical, common sense measure. It encourages companies and collaborators to actually share information internally without fear of self-destruction, patent-wise.
It is. The policy rationale is purely functional. Foster internal information sharing, allow for parallel development tracks, and promote collaborative innovation within related entities. It prevents routine internal filings or concurrent projects from unfairly blocking later improvements or related inventions developed by the same organization or its close partners.
Okay, let's take a breath. We spent a lot of time defining all the different types of prior art that can exist under Section 102.
The publications, the uses, the sales, the earlier filings. Yes.
Yeah. But, as you hinted earlier, just showing that a piece of prior art exists isn't quite enough, is it? The patent examiner, or someone challenging a patent, has to show specifically how that prior art actually invalidates the claims of the patent application.
Exactly. Now we move from does prior art exist to what does that prior art actually show?
And this brings us to the legal doctrine of anticipation.
Correct. Anticipation is the legal test, the bridge, that connects a piece of prior art to a finding that a patent claim lacks novelty under 35 U.S.C. Section 102. If a prior art reference anticipates your claim, then your claim is not novel and therefore invalid.
So what does it take for prior art to anticipate a claim? Hashtag 5.1. Anticipation, the one-to-one match.
The standard for anticipation is extremely strict. It requires a precise, explicit one-to-one match.
One-to-one, meaning what?
It means that a single prior art reference, just one document or one instance of public use or one offer for sale, must disclose every single element of the claimed invention, arranged or configured exactly as described in that specific claim.
Every single element from just one source.
Every single limitation of the claim must be found, expressly or inherently, we'll get to inherent, in that single reference.
Okay, so let's say my patent claim is for a widget with 3 key parts, A, B, and C, connected in a specific way.
Right.
If prior art reference 1 describes a widget with parts A and B but not C.
No anticipation.
And if prior art reference 2 describes part C but not A and B.
Still no anticipation by either reference alone.
So the court or the examiner can't just take reference 1 and combine it with reference 2 to show A, B, and C were all known.
Not for anticipation. That process you just described, combining multiple references to piece together the invention that's the test for obviousness under Section 103, that's a completely different legal standard, usually considered lower than anticipation.
Got it. So anticipation is like finding a perfect photograph or blueprint of your exact invention in one single earlier document or event.
That's a great analogy. It has to be a mirror image, a doppelganger, found entirely within the 4 corners of that single reference. Cases Cases like Vertigal Bros v. Union Oil Co. really emphasize this strict requirement. The courts demand that full direct match. If even one claimed element is missing from that single reference, anticipation fails. Hashtag tag 5.2. Inherent anticipation, the necessary feature.
Okay, that seems clear, if strict. But now let's tackle the trickier version you mentioned, inherent anticipation.
Yes. This is where things get more subtle and often more contentious.
How is this different from the explicit, direct, element-for-element match we just discussed?
Inherent anticipation applies when a feature or element of your claimed invention is not explicitly spelled out, not written down, in the prior art reference.
Okay, so missing.
Explicitly missing, yes. But that feature is necessarily present whenever the process or composition described in that prior art reference is practiced or made. It's an inherent, inevitable result or property.
So if I follow the instructions of the old prior art document, my claimed feature will automatically, unavoidably appear, even if the old document never mentions it.
Exactly. If that feature inevitably and naturally results from practicing the prior art, then your claim to that feature is considered anticipated, even if the person who created the prior art had no idea that feature existed or resulted.
Wow. So the prior art author doesn't need to have recognized or appreciated the inherent feature. They just have to have described something that unavoidably produces it.
Precisely. The key word there is unavoidably or necessarily. It can't be just a possibility or something that might sometimes result. It has to be an inherent property or outcome of following the prior art's teaching.
Can you give an example? This sounds quite abstract.
The classic, most famous example is Schering Corp v. Geneva Pharmaceuticals. This involved the well-known allergy drug loratadine, branded as Claritin.
Okay, Claritin. Millions took it.
Right. Schering had the original patent on loratadine. Later, scientists discovered that when a person takes loratadine, their body metabolizes it, breaking it down into various other chemical compounds, including one specific metabolite called discarboethoxyloratadine, or DCL.
Okay, a breakdown product.
Yes. Schering then obtained a new patent claiming this DCL metabolite itself as a novel compound. They argued it was never previously known or isolated.
People had been taking Claritin for years before that DCL patent was filed.
Exactly the point Geneva Pharmaceuticals made when they challenged the DCL patent. They argued that since taking loratadine necessarily and inevitably results in the formation of DCL in the patient's body,
then the prior art, the act of taking loratadine, inherently disclosed DCL, even though no one had explicitly identified or named DCL back then.
That's precisely what the court ruled. The prior public use of loratadine inherently anticipated the claim to the DCL metabolite, because DCL was the necessary and unavoidable result of that prior use.
That seems like a brutal outcome for Schering.
It highlights a really tough lesson for inventors, especially in chemistry and biotech. If your supposedly new product or process is simply the inevitable, previously unrecognized, but implicit result of an old known product or process, you haven't actually created anything novel under the law. Inherent anticipation blocks you. So if we try to pull all these threads together, connect the dots from 102A and 102B in anticipation, what we've really witnessed is this massive policy and legal shift embodied in the American Invents Act.
It feels like the U.S. patent system fundamentally recommitted itself to a clearer, arguably stricter, but definitely global standard with first-inventor-to-file.
I think that's right. The strategic landscape for inventors has fundamentally changed. The focus really shifted away from arguing over, technicalities like, was this use in this country, or did enough people see this publication?
Towards a simpler but maybe tougher question.
Yes. Was the information globally and publicly accessible in any meaningful form before you filed your paperwork at the PTO?
And that accessibility includes commercial activity, even secret commercial activity, right? The on-sale bar remains a major trigger, as the Helsinn case hammered home.
Absolutely. Once you try to commercialize, regardless of NDAs, the law basically says you've started to exploit the invention, and the clock is ticking on your ability to also claim a patent monopoly. You can't have it both ways indefinitely.
However, the inventor isn't left completely exposed. The grace period under 102B1 stands out as the most crucial strategic tool.
It really is. It gives you that precious one-year window to recover, specifically from your own necessary public disclosures, presentations, papers, maybe some limited market testing.
But we have to stress that caveat again. It only protects you from your own actions or actions directly derived from you.
Critically important. If someone else independently comes up with the same thing and discloses it during your grace period, that grace period provides no shield whatsoever. You must get your application filed before they do, or risk being barred by their independent disclosure.
So, distilling this entire deep dive into novelty down,
Yeah.
what's the absolute bottom line for you, the inventor listening? It seems it's not just about keeping secrets.
No, it's more nuanced than just secrecy. It's about controlling accessibility.
Accessibility. That seems to be the recurring theme.
It is. Novelty under the current law is defined primarily by whether the information was made accessible to the public, not necessarily whether anyone actually found it or whether it was widely known or even whether it was easy to find. Was it put out there without restriction?
And the burden is squarely on the inventor to manage that accessibility.
Completely. Once you release information into any potentially accessible domain, whether it's a library index, a trade show catalog handout, into a friend's hands without an NDA, or through a commercial transaction, the law basically presumes the world could know it, and your novelty is immediately put at risk. Vigilance is key. #outro.
So we've established that 35 U.S.C. Section No. 102 acts as this very strict gatekeeper. Its purpose is to ensure that patents are only granted for truly original ideas, things that haven't already been made public through publication, use, sale, or those earlier, sometimes secret, patent filings by others.
That's the goal. Reward genuine innovation, not rediscovery. And as we wrap up, let that concept of accessibility really sink in. Think about its implications.
Okay.
We discussed in Hall where that single copy of a doctoral thesis just sitting cataloged in a German university library was deemed available to the public and was enough to invalidate a U.S. patent.
Pretty striking example.
So here's the final thought to mull over. If that single obscure thesis counts as publicly available, what does that suggest about the patentability of an idea, maybe your idea, discussed casually in an ephemeral online forum, or in a supposedly private messaging group, or maybe even just a detailed comment on a social media post?
Even if you thought you were just talking to a few friends or colleagues.
Exactly. Even if you subjectively thought it was private, was it technically accessible? The definition of public availability is constantly expanding, especially in our hyper-connected digital age. It demands ever greater vigilance from inventors regarding even their earliest, most seemingly casual disclosures. Where does private chat end and publicly accessible begin online? That line is getting blurrier all the time.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.